Welcome to the Pacific Research Institute podcast. I'm your host, Romina Ichon. Earlier this month, I attended the annual Heritage Resource Bank Conference in Fort Lauderdale. At the conference, I caught up with Todd Gaziano, Chief of Legal Policy and Strategic Research at the Pacific Legal Foundation. He also directs PLF Center for the Separation of Powers. Todd was on a panel titled Rolling Back the Administrative State. As Washington has gained power over many decades and the administrative state has grown, decision-making has moved further away from families and local communities. Todd discusses his work through litigation to wrest power from Washington's unelected bureaucracies and returning it back to the people. Welcome to PRI's podcast, Todd. Could you explain to our listeners about how this bureaucrat power creep has quietly happened over the last few decades and how it's impacting our daily lives?
Well, it's a great series of questions, so I'll try to break it down in a few different ways. First of all, it would be terrible if Congress actually annually authorized the growth of the government and did it in a constitutional manner. But the greater problem is that Congress and, quite frankly, all three branches of the federal government cooperated in a number of unconstitutional actions. Mm-hmm. And as I'm going to try to relate, it's been going on for longer than a decade. It's only accelerated in recent decades. And what they've done is they have unleashed a regulatory state, set it in motion that kind of grows on its own. Now, it does tend to get appropriated money each year, but its power that was given to it many, many years ago is what's the biggest problem. So even more than 100 years ago, Congress started creating what I like to term regulatory agencies, and a regulatory state is a little bit easier for people to understand than an administrative state, which sounds very innocuous. But starting in the 1930s is when we have the first inflection point, and Congress started creating more of these administrative entities, and the real difference at that point was they started delegating some of the legislative power that is exclusively Congress's to these agencies. It isn't a problem to have agencies. At the time of the framing, the British government and the soon after that, our Constitution, there were agencies, but they only executed the law. So Congress essentially wrote almost all the details, and what the executive branch did in execution, and the term in law school we learned was interstitial gap filling. Interstitials from a word that means the gap between grains of sand. So they could fill in small details. And the judiciary has to interpret laws. All laws aren't perfectly clear, so they can interpret and fill in small gaps. Well, what happened in the 1930s is they started delegating broader and vaguer regulatory powers to these agencies. And then the next leap, the next inflection point was in the 1960s and 70s. They began to delegate even broader and vaguer powers to these agencies. So I'll use two examples. The FCC has power to regulate the airwaves, quote, and this is the standard, in the public interest, end quote. Well, that's an open-ended invitation to create law. So no longer is the agency just administering a fixed prohibition laws that Congress creates. There used to be a distinction between regulation and legislation, and now it's just a fiction. Another example, OSHA. OSHA was given the power to enact workplace safety standards, and then I'll add the supposed standard. And so Congress creates these agencies with different subject matters that are now, by the way, overlapping because they've created so many that every area of our life is covered by at least 2, 3, 4 regulatory agencies. But anyway, back to the OSHA example. OSHA has the power to create workplace safety standards that are either, quote, reasonable or appropriate, end quote. Well, what isn't? I mean, so essentially Congress is saying you have all of our lawmaking power in this particular area. And that trend by Congress was an unconstitutional trend. The trend of the president to accept it is an unconstitutional trend. But the third party that, starting in the 1930s and continuing later, that allowed this to happen is the courts. So the courts unconstitutionally abrogated their responsibility. They came up with a legal standard that was essentially hands-off and deference to the regulatory agencies. And then the final factor, if you don't mind me filibustering a little bit on this first answer because your question was so interesting, is that when a government agency is given an almost unlimited license to regulate, what happens? It grows.
They go to town.
It grows. It grows. It grows. And each decade. So the first decade of regulations under the Clean Water Act were bad, but they were clearly close to actually regulating navigable waters. The next decade, they went after so-called wetlands. The next decade, so each time they ratchet up, and pretty soon they're saying every area of land where water might fall that flows into a stream is covered by their jurisdiction over navigable water. It just tends to happen. And if you don't mind me telling one more little story,
Oh, absolutely.
this trend of the growth of regulatory and government agencies to grow over time, regardless of the need for them, was first really studied by a public administration professor in England, where he was studying the growth of the colonial office in England in the 50s and 60s. Well, what was interesting about that was that England was getting rid of almost all its colonies in the 40s, 50s, and 60s. So as the colonial office had less and less responsibility, it was continuing to grow. And what was the common element here? And by the way, the same thing was happening with other government agencies. The fact is, over time, government agencies justify the need for more regulators, the need for more staff. The phrase was the rising pyramid. So you start with a small period, and the people at the top want more staff, and the people in the middle then want people reporting to them, and so on and so forth. So there was a natural tendency. But Congress is supposed to be putting the brakes on. Congress is supposed to be issuing the laws. But Congress found it convenient to pass these good-sounding laws, Clean Water Act, Clean Air Act, but not taking the responsibility for the actual regulations, which are laws that govern us. So shame on Congress, shame on the president for accepting that unconstitutional power, and shame on the courts for allowing it to happen. But that's why we're in the mess we're in.
So how do you reverse that?
It's terribly difficult to reverse it, but we should remember that it took the progressives 100 years to create the unconstitutional state. They had some failures for a few decades before they then took advantage of, some would say, abused the crisis of the New Deals. Rahm Emanuel, many later decades, say you never want to let a good crisis go to waste. So the progressives knew that. So they've been wanting centralized government for many, many decades. They used whatever excuse they could have. Oh, World War I, we need to centralize government. So they centralized it a little bit, but they didn't get most of what they want. And so they finally succeeded during the crisis of the New Deal to elect a very pro-regulatory Congress, and Franklin Roosevelt finally appointed enough anti-constitutional justices to start to make that happen. So that story is important to know that, but even as bad as it was in the 30s, it got much worse in the 50s and 60s. Well, I think the high watermark for the intellectual support for the administrative state or the regulatory state has actually passed in the 1980s. So there's first an intellectual movement. I think we've made great strides, particularly in the last 30 years, in undermining the rot and the unconstitutional nature of the regulatory state. We have a few other things that are pointing to climate for change. For example, the regulatory state, as we've discussed previously, has just become so oppressive. It's now creeping into, it's not just going after big corporations who are supposedly evil, it's now starting to affect more and more average Americans. And the Trump administration is more of a result rather than a cause of deregulation. They are doing some great actions in deregulation, but their election is actually a reaction. So there's the final, I think, trigger that helps define this moment that we have to start reversing things is both George W. Bush's judicial appointments and many of Trump's outstanding judicial appointments were raised in this new milieu, this new understanding of the past 30, or came of age as professionals, understanding that it's all unconstitutional. And so there are great judges like Kavanaugh and Alito who are appointed by George W. Bush. There are other great justices and judges like Gorsuch who attacks illegal deference to regulatory agencies. And Greg Katsas, a friend of mine, was appointed to the D.C. Circuit. These are judges who are going to make a difference. So the final part of the answer is there's a bunch of organizations like Pacific Legal Foundation that have a strategic vision.
Now, for our listeners who are not familiar with the work of the Pacific Legal Foundation, could you explain your mission and in particular the work that you do?
Well, for 45 years, we have been the leading voice in attacking abusive federal and state action against individual rights. So our lodestar are the individual rights that are guaranteed in the Constitution. And in recent years, I think we have been, the leader in attacking the regulatory state, but we've primarily done it through particular statutes that we thought were extremely dangerous, like the breadth of the Endangered Species Act, the breadth of what became regulations under the Clean Water Act. The California Coastal Commission is a special problem in California and certain other states. But in recent years, we've decided we need to take on the regulatory state, qua regulatory state, and not just these programs that we've specialized in the past. And so in the recent months, we formed a Center for the Separation of Powers. And I'm privileged to help direct that. And it's going to do 2 or 3 things that are a little bit different than what PLF had done before. First of all, it is going to generate some new and innovative ideas of litigation to overturn and we can talk about some of those cases later. But it's also going to promote these same ideas to others, to our fellow travelers, to our other. We want to steal every good idea that the other constitutional groups have, and we want to promote their ideas to others. We want to promote our ideas. So we're going to have some targeted strategy conferences to help not just discuss the problems. There's been a lot of academic work on what the problems are. Now is the time to focus on the best targets of opportunity, the solutions to overturn the administrative state, knowing that we're going to, in some areas, we're only going to be able to chip away. Later, we hope to have an avalanche. And there are about 10 unconstitutional doctrines we need to overturn, and we'll focus on 3 or 4 perhaps at a time when the opportunity is right. The final thing the Separation of Powers Center is going to do is to actually work in the administrative level, both the state and the federal level, and in Congress, because there are some second best solutions to some of these problems in legislation. Ultimately, what we'd like is court rulings that restore our constitutional rights. But if we can't get everything we want immediately, we'll look to legislation, regulatory reform laws, and there are several that are very promising. State administrative reforms. We have been one of the leaders, for example, in the Congressional Review Act. Some states have something like that where the legislature has expedited procedures to review and overturn regulations. We'd like to see a lot more of that.
In an effort to roll back the power of unelected officials, the Pacific Legal Foundation has taken on a number of cases. One is on behalf of the Kansas Natural Resource Coalition, and the other is for the Pickett family, who owns a cattle ranch in Idaho. Why are these cases important?
Well, both of those cases are to more fully enforce and implement the Congressional Review Act. Now, some of your listeners know what that is now. They wouldn't have 2 years ago. But for those who may not quite understand. It was a law passed 22 years ago by actually when I was working for a member of Congress who sponsored it, that requires every federal regulation to be submitted to Congress, and then it had expedited procedures that eliminated the filibuster, for example, in the Senate, for a certain period of time for Congress to overturn them. And prior to last year, only one regulation was ever overturned. We've had 17 more that have been overturned in the past year. But we at the Pacific Legal Foundation noticed something even more powerful about it, that up until even last year, it was only used to attack what was called midnight regulations at the very end of the previous administration. And those are the ones that Congress first focused on. And we helped promote that. But we also said that if a rule that was 5 years old, 3 years old, 6 years old, had never been submitted to Congress, the time for its expedited review had not yet begun. And that the Congressional Review Act also applied to so-called guidance documents. And there were people who were skeptical about that. The Wall Street Journal wrote about it in enthusiastic ways. But just a month ago, Congress has proven our interpretation correct. Just a month ago, the House and Senate passed these resolutions of disapproval that Trump signed, making it a law to overturn a several-year-old CFPB guidance document, a misguided and illegal guidance document on auto lending. And so that precedent proved two things. It proved that, of course, guidance documents are within the definition of rules that must be submitted to Congress. And two, it proved that they weren't immunized from review if the agency didn't submit them. Well, of course they shouldn't be immunized. Of course they shouldn't be, but the law now establishes this principle. So that's the good news. But the bad news is there are hundreds and hundreds of others that still haven't been submitted. And so the suits that you mentioned in your question are two lawsuits we filed in April to help force the administration, the current administration that's probably too busy with too many other things, to actually send up the rules to Congress. One that you first mentioned is on a very good rule that our clients want sent to Congress so it can go into effect. The other consequence of not sending a rule to Congress is it's not lawfully in effect. The other rule we've sued on behalf of our Idaho ranching clients is a multi-billion-dollar, 1,000-job-killing sage grouse protection that covers 170 million acres of federal land in 10 states, including a little bit of California, Oregon, Washington, but especially states a little bit more to the east. And the problem is the Department of Interior and Agriculture that issued these rules never sent them to Congress, but is enforcing them against our clients illegally. Wow. And one of the things we've heard is, well, we're going to change them. That's fine, and we hope they do, but they've got to submit them to Congress. If they do submit this to Congress, there's a possibility, because Congress was interested in overturning them, that Congress might overturn them. So we think it's extremely important for this administration to get in the practice of sending everything to Congress, and we're actually hoping for either an executive order or an order from the head of OMB or its Office of Information and Regulatory Affairs to all agencies to prioritize the review of the old rules that were never sent, and to prioritize, they could do four things with them. They can either send them to Congress so that they go into effect, send them to Congress with a request that some of them be overturned. They could simply issue notices that, hey, these were never sent to Congress, they're not lawfully in effect, and we're not going to send them to, we disavow them. We're not withdrawing them. We're not withdrawing them because they were never lawfully in effect. And then the fourth action is to say we're not sending them to Congress, but for some rules that have been through the notice and comment process, they may have to go through a notice and comment process to repeal them. But they can use the fact that they were never sent to Congress as an additional reason, as a sufficient reason to begin that notice and comment process. And for all of those rules, if there's an internal administrative review, they still need to announce that they cannot be enforced while the review is taking place, because the first sentence of the Congressional Review Act is that no rule may take effect until it is delivered to Congress.
You know, I go to Congress to discuss PRI's work, and I know what they'll think. Oh, we're so overworked and backed up already. How can we take all of this on? It would take years. Do you get that reaction when you say to them all of these rules and regulations have to be reviewed?
I get that response all the time, and I have about 3 replies, one of which I mentioned on a panel discussion here at Resource Bank yesterday. First of all, the law is the law, and they have to be sent up to Congress, whether Congress acts on them or not. 2, we can rely on the regulated public to focus attention on the worst ones. For example, Congress tried to overturn the sage-grouse rules, and it was filibustered before they realized they could use the Congressional Review Act. That's one of the rules that they might actually be able to focus on. But 3, and this was the point I made yesterday, it is horrible if Congress thinks it doesn't have the regulatory expertise on its staff to review what the agencies are doing. They're supposed to be the lawmakers. And so if they need, I'm going to make up some numbers, but these are rough estimates. If there are 2 million regulators and staff in the executive branch agency, and Congress has different committees, if there's only a few hundred staff in the House and Senate that review regulatory matters, that's a serious imbalance that needs to be addressed. And I worked in Congress when the Republicans wanted to cut costs and reduce money, but it doesn't cut cost of government if they are so understaffed that they cannot properly review the regulations. So they need I believe, a sort of OM regulatory Office of Information Regulatory Affairs for Congress that's centralized, and each committee that has jurisdiction over regulatory agencies needs to maybe quadruple or whatever its regulatory staff so that it can properly do the job.
Another suit that you filed challenges the FDA's deeming rule, which threatens the livelihood of small vape cigarette retailers. This is an especially important issue in California because a lot of the innovative products are coming out of the state. What's at issue here?
Well, this is a special and fairly novel constitutional challenge to FDA rulemaking, and the deeming rule is a particularly bad rule I'll mention in a minute, or I'll mention now. The so-called deeming rule just deemed vaping to be subject to regulation of the Tobacco Control Act, but vaping liquid is not smoke, and it doesn't contain any tobacco. So that was a wrong-headed decision, and the impact of it may lead to 6 million lives lost. Our clients, many of them got into the business because vaping has been shown to be the most effective smoking cessation method. And there are peer-reviewed medical journals that, and particularly the British medical establishment, are promoting vaping because they know it is the most effective way of stopping smoking. And those who then may become, reliant on the nicotine in vaping suffer, some studies, 95% or less harm than tobacco smoke. But this regulation, this FDA regulation, may kill the industry. Our clients are small vape shop owners, again, the people who got into the business to help smokers quit. But the constitutional problem is that FDA delegated the authority to issue this rule and 400 of its past major rules over the past 20 years to career employees. That's just unconstitutional. 31 years prior to our filing our lawsuit in January, the Supreme Court ruled that rules that bind the public can only be issued by officers of the United States. You cannot delegate it to career employees. We believe that since that 31-year time, it's become even more clear that only principal officers confirmed by the Senate and appointed by the president can issue rules. But even if we don't get the courts to agree with us that only principled officers should issue rules, clearly employees cannot. So the employee who issued this rule, her name is Leslie Cooks, or Cux, it's K-U-X, I'm not sure how it's pronounced.
What was her title?
She is Deputy Commissioner of Policy, and she's been Deputy Commissioner of Policy. It's a career position.
And not confirmed.
Not only not confirmed, it's not even appointed by the president in any of the methods that the appointments clause of the Constitution.
Not hired by Scott Gottlieb or the FDA.
They may actually be hired by one of these officials, but Scott Gottlieb isn't the head of a department. And so the principal officers must be nominated by the president and confirmed by the Senate, and then appointed by the president. Inferior officers must be vested by Congress. The office must be created by Congress, and then they must be appointed either by the president or the head of a department. And Leslie Cooks was not appointed by the head of the department pursuant to a statute. Her office was not created by a statute. She does not have authority. But I pose this question here at Resource Bank to the audience also. We are certainly right that these last 400 rules that FDA issued are unconstitutional. But the president, even if we haven't won our case in the Supreme Court yet, should still issue an order, I think, to every agency: you shall not delegate rulemaking authority to the thousands and thousands and thousands of bureaucrats who you don't supervise. In my administration, and some other president can potentially overrule it until Pacific Legal Foundation wins its Supreme Court case and establishes this as a matter of Supreme Court law, only principled officers confirmed by the Senate can issue rules. And what's interesting at HHS is that its sister agency, the Center for Medicaid and Medicare, does have a Senate-confirmed head, but instead of even issuing rules himself or herself, they seek the cabinet secretary, the secretary of HHS, to issue their rules. So the constitutional method of rulemaking can be done.
Yeah.
It really can be done. But cabinet secretaries and other principal officers should be the only ones issuing rules. It's bad enough that they have such broad authority to begin with, and we want to change that. But until we change that, the framers understood that politically accountable people are more sensitive to the public than non-politically accountable. That's why they put the appointments clause in the Constitution. That's why they required certain action to be taken by politically appointable people. This is all, the framers understood all this. And the progressives wanted to undermine it. The progressives understood all this too. The progressives wanted more lawmaking by bureaucrats because they thought they were technical experts. They, were well-meaning, extremely, mistaken and dangerous. But, their well-meaning theory is that they wanted to get the politics out of lawmaking, and they wanted these technical bureaucrats to regulate all our lives. And that's what we've got, and that's what we need to overturn.
Finally, since the Pacific Research Institute's headquarters is located in San Francisco, next door to wine country, we always ask every podcast guest for a wine, beer, or cocktail recommendation for our listeners. After the Resource Bank conference, Todd, what will you be drinking?
Well, often drink bubbly, which to celebrate, but on a nightly basis, wine is my favorite. And I had a wonderful Stag's Leap Artemis Cabernet 2015 last night, and I would love to end this conference with another from that particular vintage and a producer.
Thanks so much, Todd, for joining us.
Thanks so much for having me.
Thanks to our guest, Todd Gaziano of the Pacific Legal Foundation. To find out more about his work at PLF, visit pacificlegal.org. And after you've visited PLF's website, don't forget to go to PRI's website at pacificresearch.org and read our latest studies and check out our blog Right by the Bay. And if you like this episode, please tell your friends and subscribe to PRI's podcast at iTunes, Google Play, Stitcher, or TuneIn. And please do us a favor and give us 5 stars. You can also listen to our podcast on PRI's YouTube page, youtube.com/Pacific Research 1. That's the number 1. Thanks for listening. I'm Rowena Ichon. We hope you'll come back again for another episode of PRI's podcast.